Welcome to the next lecture of American Government 2. I'm your host, Dr. Michael Baggs, and our topic this week is the Supreme Court and the federal court system. Understanding the federal judiciary. The framers viewed the federal judiciary as an important check against both Congress and the president, but the judiciary lacked the institutional resources of the elected branches. As Alexander Hamilton wrote, the executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse. So, in order to ensure the judicial check, the framers insulated the judiciary against both the public opinion and the rest of the government. The framers rejected direct judicial election to protect the federal judiciary from shifts in public opinion. That was the method used to select many judges in the colonies, and it is still used today to choose many state and local judges. The framers also excluded the House, the more representative of the two bodies of Congress, from any role in either selecting or confirming federal judges. To protect the judiciary from Congress as a whole, no limits were allowed on judicial terms. Federal judges served during good behavior, which typically means for life. And finally, to prevent Congress from assessing a financial penalty against the judiciary, judges' salaries cannot be reduced once confirmed. These early structural decisions were essential to protect the judiciary's independence. The legal system. Criminal law is the branch of law that regulates the conduct of individuals, defines crimes, and specifies punishments for criminal acts. In a criminal trial, a person's liberty can be at stake. Defendants who are found guilty of charges brought against them may be fined or sent to jail. In a criminal trial, the government is always the plaintiff or the party that brings the charges to court. Defendants generally have the right to a trial by jury in criminal trials. Civil law is the branch of law that deals with disputes that do not involve criminal penalties. Civil law governs relations between individuals and defines their legal rights. These disputes may be among individuals, groups, corporations, and other private entities, or between such litigants and the government. In a civil trial, penalties are predominantly monetary. There is no right to a government provided attorney in civil cases, and there is no constitutional right to a jury in state civil trials. The federal government brings civil cases to court, as do individuals, state governments, cities, corporations, and any other party alleging a violation of federal law or the United States Constitution. The plaintiffs begin a civil suit by filing a complaint requesting a judgment. They can do so, however, only if they have standing. This is where they have experienced or are in immediate danger of experiencing direct and personal injury. Judicial federalism. Unlike most countries, which has a single national judicial system that makes all decisions on criminal and civil laws, the United States has both federal and state courts. Each state maintains a judiciary of its own, and many large cities and counties have judicial systems as complex as those of the states. As in the federal system, state judicial power is divided between trial courts and other special courts, such as traffic courts, and one or more levels of appellate courts. State courts primarily interpret and apply their state constitutions and state laws. More than 97% of all cases go through state court. When their decisions are based solely on state law, their rulings may not be appealed to or reviewed by federal courts. Only when a decision raises a federal question requiring the application of the Bill of Rights or other federal law is the Supreme Court able to review it. Federal courts do have writ of habeas corpus jurisdiction, or the power to release persons from custody if a judge determines they are being detained unconstitutionally. Federal courts may review criminal convictions in state courts if they believe that an accused person's federal constitutional and legal rights have been violated. Federal court jurisdiction. Cases involving federal laws, treaties with other nations, or the Constitution go to federal court. These areas are the official jurisdiction or sphere of power and authority of the federal courts. Federal courts will also hear cases in which the U.S. government is a party or a civil suit that involves citizens of more than one state and more than $75,000 is at stake. However, this depends on the preference of the plaintiff, who can opt to pursue the case in state courts instead. Unlike the legislative and executive branches, the federal judiciary is a passive and reactive branch. It does not instigate cases or conduct its own investigations, nor can it resolve every issue that comes before it. Federal judges decide only justiciable disputes according to the Constitution. They are to decide cases and controversies that have not been resolved by the parties or are not mute because one or both parties have died or dropped the case. It is not enough that a judge believes a particular law to be unconstitutional. A real case must be litigated for a judge to reach that decision. Hypothetical harm is also not enough to warrant court review. Jurisdiction. If a case belongs in federal court, the next question is which federal court has jurisdiction. Congress assigns jurisdiction based off geography. Our nation is currently divided into 94 judicial districts, and these judicial districts are then organized into the 11 regional circuits and the D.C. Circuit. Each circuit court exercises appellate jurisdiction over district courts within its region. Federal court system. Article 3 of the Constitution is the shortest of the three articles establishing the institutions of government. Yet, as brief as it is, it instructs the judiciary to resolve several kinds of cases, including, for example, those to which the United States is a party in enforcing the laws and disputes between citizens of two or more states. Article 3 is not the only part of the Constitution dealing with the federal judiciary, however. In Article 1, the framers also gave Congress the power to establish all tribunals inferior to the Supreme Court, which meant that Congress could establish the lower courts that we discuss next. The first Congress used this power to create a hierarchy of federal courts with the Judiciary Act of 1789. This law created the three-tiered federal judiciary system that exists to this day. Level 1. District Courts. Although the Supreme Court and its justices receive most of the public attention and news coverage, district courts are the workhorses of the federal judiciary. Also known as federal trial courts, these courts operate in each state, the District of Columbia, and U.S. territories. There are 678 judgeships in the 94 district courts across the county, at least one in every state. District courts are the trial courts where nearly all federal cases begin. District court judges hold trials and decide cases individually. Only one judge is assigned to each case except for cases where a statute calls for a three-judge panel. District court decisions can be appealed. Level 2, Circuit Courts of Appeal. District court decisions can be appealed or taken to a higher court for further review, should the losing party allege that an error occurred during the trial. For example, the losing party might contend that the trial judge issued inappropriate jury instructions or that evidence was erroneously admitted. It is not sufficient for a party to appeal simply because they did not like the trial court's decision, nor can the government appeal a not guilty verdict in a criminal proceeding. Roughly 20% of all lower court cases are reviewed by federal appeals court, and nearly all of these appeals are reviewed by the federal courts of appeals. The federal court system has 13 circuit courts of appeals. 11 are determined by geography, and these courts hear appeals from within their districts. The District Court of Columbia Circuit handles appeals from the Federal District Court for the District of Columbia. They hear the largest number of cases challenging federal statutes, regulations, and administrative decisions. Also, a federal circuit hears specialized cases such as those involving patent law or those decided by the U.S. Court of International Trade. Circuit courts normally operate as panels of three judges, and less than 1% of their decisions are appealed to the Supreme Court. If the Supreme Court refuses to hear the appeal, the case is over. The Supreme Court. The Constitution established only one court of appeals for the entire nation, the Supreme Court, or the court of last resort. The U.S. Supreme Court is the highest court in the nation. Once the Supreme Court makes a decision, the dispute or the case is over. Compared with Congress and the presidency, the Supreme Court has changed the least since its creation. There are 9 justices on the Supreme Court today compared with 6 in 1789. The Constitution does not specify the number of justices. Congress has the authority to change the court's size. Jurisdiction of the Supreme Court. Original jurisdiction is the authority to consider a case initially. Appellate jurisdiction is the authority to hear appeals from a lower court's decision. The Constitution gives the Supreme Court original jurisdiction in a limited variety of cases: a case between the United States and one of the 50 states, controversies between 2 or more states, cases involving foreign ambassadors or other ministers, or lawsuits brought by one state against citizens of another state or against a foreign nation. In all of the cases, the Supreme Court has appellate jurisdiction. Federal courts may decide only cases or controversies arising under the Constitution, a federal law, a treaty, or admiralty and maritime law, cases brought by a foreign nation against a state or the federal government, and diversity suits, lawsuits between citizens of different states if the amount of the controversy exceeds $75,000. Judicial review. One of the most important powers of the Supreme Court is judicial review. This is the power of the court to examine and, if necessary, invalidate or declare unconstitutional actions taken by the legislative and executive branches. The Constitution does not specifically grant the Supreme Court the power of judicial review. The The Supreme Court asserted this power under Chief Justice John Marshall in the Marbury versus Madison opinion. The details of the case are such. The outgoing president, Adams, appointed many officials after losing his election, and Marbury was one of those appointments. However, his appointments contract was never sent, and Jefferson's Secretary of State, Madison, refused to honor the appointment. Marbury sued and took his case directly to the Supreme Court. After the court heard the arguments of the case, they made two decisions. First, Marbury had a right to his commission because all appropriate procedures were followed. Secondly, Marshall addressed the most important issue of the opinion, the propriety of the Supreme Court's jurisdiction over the case. Marbury argued that the Judiciary Act of 1789 gave the Supreme Court original jurisdiction over his case. Because Marbury filed his suit directly with the Supreme Court, the court would need to exercise original jurisdiction to hear it. If the court's jurisdiction was limited to appellate jurisdiction only, it would be unable to properly hear and decide Marbury's directly filed case, since it had not been the first to hear it in a lower court and then appealed to the Supreme Court. The court agreed with Marbury and interpreted the relevant section of the Judiciary Act to authorize mandamus on the original jurisdiction. However, Marshall noted that this authorization clashed with Article 3 of the U.S. Constitution, which created the Supreme Court and establishes its original and appellate jurisdiction. Marshall's interpretation of the Judicial Act meant that it took the initial scope of the Supreme Court's original jurisdiction and expanded it. Marshall ruled that Congress cannot increase the Supreme Court's original jurisdiction as it was written in the Constitution. Therefore, that portion of the Judiciary Act violated Article 3 of the Constitution. The Constitution meant that its coordinate branches should be checks on each other, but the opinion, which gives judges the right to decide what laws are constitutional and what not, are not only for themselves in their own sphere of action, but for the legislative and executive also in their spheres would make the judiciary a despotic branch. Thomas Jefferson. Perhaps he was just a little upset that they ruled against him. Judicial review of state laws. The U.S. Supreme Court can review the constitutionality of state laws based on the Supremacy Clause of the U.S. Constitution. The Supremacy Clause states that laws passed by the national government and all treaties are the supreme law of the land and superior to all laws adopted by any state or any subdivision. The court has used judicial review to strike down state laws that violated rights or privileges guaranteed by the Constitution or federal statutes. Also, the Judiciary Act of 1789 conferred on the Supreme Court the power to reverse state laws and constitutions whenever they conflict with the United States Constitution. Judicial review of federal agencies. Federal agencies often make critical decisions about how to administer and implement federal laws. This delegation of power to federal agencies can lead to conflicts. The court has had to rule on the scope of delegation of power to federal agencies and whether federal agencies' actions are consistent with Congress's expressed or implied intent. As long as federal agencies develop rules based upon permissible construction or reasonable interpretation of a law and use a prescribed formal rulemaking process, the judiciary most often will defer to them. Judicial review of the president. The court also reviews presidential actions when these are challenged by individuals, groups, or members of Congress. The federal bench has, more often than not, upheld assertions of presidential power in foreign policy, war, and emergencies, as well as administrative authority. Recent cases related to the war on terror, however, have placed some limits on presidential authority. In Hamdi versus Rumsfeld, the court ruled that a U.S. born Taliban soldier was entitled to a lawyer. In a later case, Trump versus Hawaii, the court upheld the use of presidential power to ban certain travelers who the president determined might pose a risk to the security of the United States. Judicial review of acts of Congress. The court has struck down only 160 congressional acts. Instead of striking down acts of Congress, the courts will typically try to interpret them so that they square with the Constitution. Judicial review has come to be accepted as natural, if not intended. The Chief Justice. Like all lower level federal judges and the rest of the Supreme Court justices, the Chief Justice of the United States is appointed by the President and confirmed by the Senate. The Chief Justice heads the entire federal judiciary and has special administrative responsibilities in overseeing the operation of the judiciary, such as assigning judges to committees, responding to proposed legislation that affects the judiciary, and delivering the annual report on the state of the judiciary. Within the Supreme Court, the Chief Justice is only first among equals, even though periods in the court history, such as the Warren Court, are often named after the Chief Justice. The Chief Justice sets a tone, controls the conference, and assigns the most opinions, and usually takes the most important nation changing decisions for himself. Solicitor General. Attorneys in the Department of Justice and other federal agencies participate in more than half of the cases the Supreme Court agrees to decide and therefore plays a crucial role in setting the court's agenda. The Solicitor General is responsible for representing the federal government before the Supreme Court and is sometimes called the 10th Justice. Because the U.S. government may not appeal any case upward without the Solicitor General's approval, the Solicitor General has significant influence over the kinds of cases the Supreme Court eventually sees. The Solicitor General also files amicus curiae briefs in cases which the federal government is not a party. Amicus curiae is Latin for friend of the court, and it references when a person or group who is not a party to a case but has a strong interest in it. They can petition the court for permission to submit a brief in the case intending to influence the court's decision. The practice of filing amicus curiae briefs by the Solicitor General guarantees that the Department of Justice is represented if a suit questions the constitutionality of an act of Congress or the executive branch. The Solicitor General may also use these briefs to bring to the court's attention the views of the current administration. Law clerks. Beginning in the 1920s and 1930s, federal judges began hiring the best recent graduates of law schools to serve as clerks for a year or two. As the judicial workload increased, more law clerks were appointed, and today each Supreme Court justice is entitled to 4. These are young people who have graduated from a leading law school and have previously clerked for a federal or state court. Securing a Supreme Court clerkship enhances the career of those chosen, and many federal judges were themselves once clerks. In fact, five of the current U.S. Supreme Court justices, Chief Justice John Roberts and Associate Justices Stephen Breyer, Atlanta Kagan, Neil Gorsuch, and Brett Kavanaugh, were all Supreme Court clerks early in their career. Breyer has since retired. When Justice Gorsuch joined the court in April 2017, it marked the first time a former clerk served on the court with a justice for whom he worked, in this case, Justice Kennedy. Each justice picks his or her own clerks and works closely with them throughout the term. In addition to screening cases, clerks prepare draft opinions for the justices. The Supreme Court in action. The Supreme Court is a unique institution. Its term runs from the first Monday in October through the end of June. The justices listen to oral arguments for 2 weeks each month from October to April, and then adjourn for 2 weeks to consider the cases and to write opinions. By agreement, at least 6 justices must participate in each decision. Cases are decided by a majority vote. In the event of a tie, the decision of the lower court is sustained. A closely divided court operating without its full membership, such as the Supreme Court in the wake of Justice Scalia's death, might well end up in a tie in one or more cases. Rather than hearing a case where a tie is likely, the court can reschedule those cases to be heard at a later time, or even schedule re-argument in a case in which arguments have already been made. The Supreme Court has developed specific rules that govern which cases within its jurisdiction it will hear and it will not hear. Case must involve an actual dispute, not a hypothetical one. Parties to a case must have standing. They must have a substantial stake in the outcome of the case. The court will not hear cases on issues that it considers to be moot, a criterion used to dismiss cases that are no longer require a resolution. If the issue has already been resolved, then there will be nothing to address. The rules for hearing a case are established by the Supreme Court and Congress. Congress passed the Act to Improve the Administration of Justice in 1988, wherein the Supreme Court has not been obligated to grant review of most cases that come to it on appeal. Its appellate jurisdiction is almost entirely up to its own discretion. The overwhelming majority of cases appealed to the court will be denied review. Writs. Most cases reach the court through a writ of certiorari, a formal petition requesting the court's review. The court decides whether to move forward based on the rule of four. If 4 justices are sufficiently interested in a petition, it will be granted and the case brought up for review. Rule 10, the last resort. This rule is also activated when a circuit court makes a decision on matters of federal law that should be settled by the Supreme Court, or when a circuit court decisions are at odds with a Supreme Court decision. The law clerks also have some influences on what cases are heard by the court. Due to the sheer number of cases that are appealed to the Supreme Court, the clerks work as a group in what they call a cert pool to read the petitions and write a memo on each recommending whether review should be granted. Contrary to the way it's often portrayed in the press, denying a writ of certiorari does not mean the justices agree with the decision of the lower court, nor does it establish precedent. Refusal to grant a review can indicate all kinds of possibilities. The justices may wish to avoid a political hot potato, or they may be so divided on an issue that they are not yet prepared to take a stand, or they may want to let the issue percolate in the lower court so that the court may benefit from their rulings before it decides. Briefs. After a case is granted review, each side prepares written briefs presenting their legal arguments, relevant precedents, and historical background for the justices and their law clerks to study. In writing these briefs, the appellants are often aware of the justice's views or concerned about their case, and they attempt to address those concerns. Often, outside groups interested in the case will file an amicus curiae brief. Oral arguments. After the court grants review, a case is set for oral arguments. During the oral arguments, counsel for each side is usually allowed only 30 minutes. In order to ensure compliance with this rule, lawyers use a lectern with two lights. A white light flashes. In order to ensure compliance with this rule, lawyers use a lectern with two lights. A white light flashes 5 minutes before time is up, and when the red light goes on, the lawyer must stop, even in the middle of a sentence. Although the format is quite formal for the attorneys arguing before the court, the environment for the justices can seem informal. Sometimes, to the annoyance of attorneys, justices talk among themselves or consult briefs or books during oral arguments. Other times, if justices find a presentation particularly bad, they will tell the attorney so. The justices often interrupt the lawyers to ask questions and request additional information. The conference. When in session, the justices meet on Friday mornings to discuss the cases they heard that week. These conference meetings are private. No one is allowed in the room except the justices themselves. The Chief Justice presides, usually opening the discussion by stating the facts, summarizing the questions of law, and suggesting how to dispose of each case. Each justice, in order of seniority, then gives his or her views and conclusions. The justices typically do not view this as a time to try to convince others of their views on the case. That will come later as drafts of the opinion are circulated between the chambers. After each justice has given his or her view of the case, the writing of the majority opinion is assigned. By practice, if the Chief Justice is in the majority, he can either assign the opinion to a justice also in the majority or choose to write the opinion himself. If he is not in the majority, the most senior justice in the majority makes that determination. Opinions. The Supreme Court announces and explains its decision in opinions of the court. These opinions are the court's principal method of expressing its views and reasoning to the world. Their primary function is to instruct state and federal court judges on how to decide similar cases in the future. Although the writing is assigned to one justice, the opinion must explain the reasoning of the majority. Consequently, opinions are negotiated documents that require the author to compromise and at times bargain with other justices to attain their agreement. The document must win the support of at least four justices. Assisted by their law clerks, the assigned justice writes a draft and sends it to the colleagues for comments. If the justice is lucky, The majority will accept the draft, perhaps with only minor changes. If the draft is not satisfactory to the other justices, the author must rewrite and recirculate it until a majority reaches an agreement. If a justice agrees with the majority on how the case should be decided but differs on the reasoning, that justice may write a concurring opinion. Dissenting opinions. Justices who disagree with the majority may choose to publicize their disagreement in a dissenting opinion. These opinions may be used to express irritation with the outcome. They also may be written to signal to the defeated side that their position did have some support, or to persuade a swing justice to join their side on the next round of cases on a similar topic. Dissents act like an appeal to keep bringing cases to the court. They can influence future arguments. After the court decides, victory in the Supreme Court does not necessarily mean that the winning party gets what they want. Although the court resolves many issues, it also sometimes remands the case, sending it back to the lower court with instructions to act in accordance with its opinion. The impact of a particular Supreme Court ruling on the behavior of individuals who are not immediate parties to a lawsuit is more uncertain. The most important rulings require a change in the behavior of thousands of administrative and elected officials. Given the Supreme Court's inability to implement its own decisions without the support of the other branches, its pronouncements may simply be ignored, particularly if they are unpopular at the time. For example, despite the court's holding that it is unconstitutional for school boards to require students to pray in school, some schools continue this practice. And for years after the Supreme Court held public school segregation unconstitutional, many school districts refused to integrate, and some even closed their public school systems, as in Prince Edward County, Virginia, so as to avoid integration. Influences on court decision making. In deciding cases, courts apply statutes, which are laws, and legal precedents, which are prior cases whose principles are used by judges as the basis for their decision in the present case. These precedents are applied under the doctrine of stare decisis, a Latin phrase to stand by that which is decided. Judges are expected to abide by previous decisions of their own courts and by rulings of superior courts. Precedents over time have developed into a body of principles called common law, which are a body of unwritten laws established by the courts. Common law influences the decision making process in unusual cases where the outcome cannot be determined based on existing statutes or written rules of law. Common law, also known as case law, relies on detailed records of similar situations and statutes because there is no official legal code that can apply to a case at hand. The judge presiding over a case determining which precedents to apply to that particular case. The example set by higher courts is binding on cases tried in lower courts. This system promotes stability and consistency in the U.S. legal justice system. However, the doctrine is not very restrictive. Indeed, lower court judges sometimes apply precedents selectively to raise additional questions about an earlier higher court decision or to give the higher courts a chance to change precedent entirely. Stare decisis is even less controlling in the field of constitutional law. Because the Constitution itself, rather than any one interpretation of it, is binding, the court can reverse a previous decision it no longer wishes to follow, as it has done hundreds of times. Supreme Court justices are therefore not seriously restricted by stare decisis. Since 1789, the Supreme Court has reversed nearly 200 of its own decisions and overturned nearly 180 acts of Congress, as well as nearly 13,000 state constitutional and legislative provisions and municipal ordinances. Justices may also differ in their judicial philosophy. Judicial restraint is a judicial philosophy whose adherents refuse to go beyond the clear words of the Constitution in interpreting the document's meaning. Judicial activism is a judicial philosophy that posits that the court should go beyond the words of the Constitution or a statute to consider the broader societal implications of its decisions. The philosophy of activism versus restraint is sometimes a smokescreen for the political ideology of the justices. The political leanings of the justices play an important role in their decisions. Liberal judges have been associated with judicial activism, and conservative judges with judicial restraint. Recently, however, conservative judges who had once called for restraint have actually become activists when seeking to undo the work of their liberal predecessors. Outside groups and other legal actors can also influence the court's decisions. Interest groups and amicus curiae briefs may influence a justice's view of the case or the implications of a particular outcome. The Chief Justice can also affect decision making by the way they frame a case at the conference, as well as by their choice of the justice to write the opinion based on the conference vote. Law clerks can also affect the court's decisions by the advice that they give their justices, as well as by their role in reviewing the cases appealed to the court. Judicial revolution. There has been substantial innovations in judicial policies. The court has been at the forefront of sweeping changes in the role of the government and the character of American society. The courts have made substantial decisions affecting the lives of every American, such as rulings on desegregation, legislative apportionment, criminal procedure, voting rights, and more. Since the 60s, there has been a significant changes in judicial procedures that includes a liberalized concept of standing, which allows almost any group to challenge the actions of an administrative agency. There's also the practice of fee shifting that allows citizens who have successfully sued a public official to collect attorney's fees and costs from the government. People now bring their grievances to the courts rather than Congress or the executive branch. Judicial injunctions. The injunction is an equitable remedy that enables the court to control a party's conduct either by prohibiting or requiring action by a party. There is no statute or Supreme Court case that has defined what a nationwide injunction is. Although no one denies that district courts have the power to enjoin a defendant's conduct anywhere in the nation as it relates to the plaintiff. There is, however, sharp disagreement that exists over the court's ability to issue relief as applied to non parties. As presidents have expanded the role of executive orders and administrative actions, nationwide injunctions issued by the courts have likewise increased. And these nationwide injunctions are increasingly partisan. Of the 78 nationwide injunctions issued by the courts during both the Trump and Biden administrations, 93.6% of those injunctions were issued by judges appointed by a president of the opposing political party. Often, it is the policies that relate to politically hot button issues or a president's policy priorities that are targeted for legal action. Structural features of litigation exacerbate the politicization of the injunction. First, the ability of plaintiffs to target particular courts and forum shop for judges who are most likely to honor requests for injunctive relief results in a race to the right courthouse. Two-thirds of all California federal district judges have been appointed by a Democrat. The opposite is true in Texas. Nationwide injunctions are a powerful tool for political opponents who can challenge the policy in multiple venues. Successful defense against a nationwide injunction in one court is barely a win for the government at all, because that decision has no restrictive effect on new plaintiffs. Other plaintiffs are free to bring the exact same lawsuit elsewhere and shop till the statute drops. All it takes is one judge siding with the plaintiffs to enjoin the challenged law. When judges in the red state of Texas halt Obama's policies and judges in the blue state of Hawaii enjoin Trump's, it tests the limits of the public's imagination to argue that the federal judiciary is impartial, nonpartisan, and legitimate. This perception is exacerbated by the fact that injunctions are disproportionately issued by more extreme judges. These judges were selected precisely because the plaintiffs saw them as especially ideological and unafraid to reach beyond principles of judicial restraint. These judges then determined policy for the rest of the country. The politics of appointing judges. The Constitution sets absolutely no requirements for serving on the Supreme Court, nor did the first Congress create any requirements for the lower courts. Because judges were to be appointed by the President with the advice and consent of the Senate, the framers assumed that judges would be experienced in the law. The appointment process gives presidents and the Senate ample opportunity to influence the direction of the courts. George Washington established two precedents in judicial appointments. First, his appointees were his political and ideological allies. All of Washington's appointees belonged to his Federalist Party. Second, every state was represented on some court somewhere, thereby ensuring at least some judicial representation across the nation. Presidents have continued to follow Washington's lead on these 2 points. They nominate judges who are likely to agree with them on the key issues before the courts and tend to nominate judges from their own party. Presidents see these nominations as one of the most important legacies of their time in office. Indeed, if a president is able to appoint a 50-year-old justice, that person could continue to affect law in the United States for 30 years or more beyond the president's term. The primary political determinants that presidents utilize to select their nominations include representational, doctrinal, and professional. The representational criteria is perhaps the most political because the president's calculus includes the nominee's race, gender, political party, religion, and geographical origin. None of these factors can be characterized as anything but political. However, these are short term considerations. The doctrinal criterion assesses the nominee's political and judicial philosophy, and it is perhaps the most important to the president because its impact on the court will far outlive their administration. Senate advice and consent. Judicial nominations are referred to the Senate Judiciary Committee for a hearing and a committee vote before consideration by the entire Senate, where they are confirmed with a majority vote. The Constitution, however, never specified what criteria the Senate should use to evaluate judicial appointments. The Senate's role very quickly evolved into what is best understood as largely beyond the operation of norms of legal rights or wrong. Instead, it involves mainly questions of prudence, judgment, and politics. The Founding Fathers designed the whole process as a political one. The presidential nominations to the Supreme Court were made with political considerations in mind, and clearly the Senate viewed its consent powers as being within the political sphere. Thus, in the ensuing century, Supreme Court nominees were rejected for practically any reason whatsoever. They were rejected because of the nominee's political views, political opposition to the incumbent president, a desire to hold the vacancy for the next president, senatorial courtesy, interest group pressure, and, on occasion, even the nominee's failure to meet minimum professional standards. Opposing nominations on purely political grounds are largely deemed inappropriate, so the debate usually centers on competence or whether the nominee is outside of the mainstream of judicial philosophy. Yet, in modern political rhetoric, judicial philosophy mainly translates into rights we like. So, this debate is merely a facade for the real question: does the nominee support the rights we like? The Senate is not compelled to offer any explanation for rejection vote, and the debate over what standards the Senate should use remains and only heats up during a confirmation hearing. Recess appointments. Even if the Senate delays or rejects a nomination, however, presidents have the option of making a recess appointment after the Senate adjourns at the end of a session. Presidents have made more than 300 recess appointments to the federal courts since 1789, including 15 Supreme Court justices who were initially seated as recess appointments. With the Supreme Court's 2014 decision on challenges to President Obama's recess appointments, president's power to staff administrative and judicial vacancies during short Senate recesses was greatly diminished. The court ruled that only when the Senate is recessed for 10 days or longer is the president permitted to make such appointments. Given that most Senate recesses are far shorter than that, there will be little potential for recess appointments to be made going forward. Scrutiny. Supreme Court candidacies are typically more heavily scrutinized than our lower court nominees, and the Judiciary Committee hearings are certainly subject to greater media coverage. There have been 37 unsuccessful nominations to the Supreme Court of the United States. Of these, 11 nominees were rejected in Senate roll call votes. 11 were withdrawn by the president, and 15 lapsed at the end of a session of Congress. The difficulty that presidents face in making appointments to the federal courts is not going away, particularly if their party does not control the Senate. Presidents of both parties have been faced with Senate obstruction and delay, and current conditions are likely to worsen given the rancor that characterized the last few appointments to the Supreme Court. The end.